Well, thank you.
So in this presentation, what I want to talk to you about is renegotiation and dispute resolution. These sorts of agreements are routinely renegotiated. And in this talk, we'll talk a little bit about why that is, and I'll give you some sort of suggestions for how you can facilitate renegotiation, and also talk a little bit about how you can resolve disputes that come up in this area. So, why do licensors seek to renegotiate? The main reason that I see is licensee underperformance. Although I've put a bullet here where I say the licensee is making too much money, and occasionally that's a reason that licensors want to negotiate, I would say the more common reason that licensors want to renegotiate, either in the middle of a term or at a renewal period, is that the licensee just, isn't adequately exploiting the market, or isn't, say, doing adequate research and development. Maybe they got some early stage technology, they were supposed to productize it and launch it into a market, and they're just not, at least in the eyes of the licensor, being very effective at that. So, and that obviously is it's more of a problem under a sole or exclusive license. So that is the predominant reason why licensors want to renegotiate. The other time when licensors might renegotiate if the licensee is making too much money. This tends to happen more with some copyright works, trademarks, things like that. Occasionally in technology licenses, but sometimes if it's just wildly successful, the licensor looks at the terms and says, that's wildly successful, I should be making a higher royalty rate. Okay. Licensees want to renegotiate usually, almost always, because they want to pay less, because they have concluded that whatever they agreed to in terms of royalty rates or minimum annual royalties, or whatever the financial terms are, they've concluded that it would be fair if they were paying materially less to the licensor. Sometimes, and there's various reasons. Sometimes they just think they divided the pie wrongly with the licensor. Sometimes they want more rights. Sometimes they want to reallocate risks. Quite often they want to do that because it turns out that the product is less profitable than predicted. So it could be that the expenses, either the research and development expenses, or maybe the cost of input materials is higher than expected. Maybe the licensee is enjoying lower sales, or not enjoying, but suffering lower sales than expected. And that's creating higher per unit, that should be fixed costs, not variable costs. Maybe there's more competition than expected. Maybe the market's smaller than predicted. Now, of course, with many of these things, if not all of them, there's also the challenge with these reasons, which are often quite legitimate, but the challenge with these reasons might be that the licensor could look at it and say, these are problems, licensee, that you've brought on yourself. So the licensor might look at these reasons and say, I don't want to reduce your royalty rate, because the truth is, licensee, you're not as good as you thought you would be at being a licensee. Your expenses are higher than expected because you're not negotiating good deals for your input materials. Your sales are lower than expected because you're not very good at sales and marketing. There's more competition than expected because even though there's a lot of opportunity here, licensee, you're not exploiting it very well. You know, and the fact that the market is smaller than predicted is, you know, that's a risk that we both took going in. Another big reason why licensees often want to pay less is that the technology doesn't work as well as expected, or it's not as important as expected. So some ways to talk about this or characterize this is sometimes the licensed IP is a smaller component of the product or service than expected. So you see this frequently, you know, in licensing out of hospitals and universities or research agencies like the National Research Council, where they IP is licensed for a product, and it's thought that the licensed IP will be the central part, the most significant part of the licensed product or service or activity. But it turns out that in fact it's a smaller component of it. It turns out that, you know, the licensee had to do substantially more research and development than they thought. Maybe they needed to license in third-party IP rights, so maybe this is linked in with freedom to operate. You know, it happens that sometimes, even when the licensee is experienced and acting totally in good faith, it's just a lot harder to turn this into a profitable product that gains good sales than had been thought. Now, this tends to be a less common problem with pharma and biotech, since the development pathway and the regulatory pathway is so well defined, right? So when I do sort of licensing or co-development agreements in the area of pharma or biotech, usually the risk there is, you know, the licensors can say, listen, we've got a pretty good idea what the common royalty rates here are. Often there's a royalty stacking clause, so that if third-party rights are required, it's clearly defined in the contract how those costs are going to impact the royalties to be paid to licensor. And the real risk in pharma and biotech is that it won't pass its clinical trials. You know, that happens. But if it does pass those clinical trials, usually the market's fairly well defined. Usually there will be a market. So that's that. These issues don't play out quite the same way in a lot of areas of pharma and biotech. Another reason that licensees often want to pay less or pay a lower royalty rate is that the rights aren't as strong as expected. Maybe unexpected validity attacks have arisen. Maybe the rights are easier to design around than originally thought. The scope of issued rights are more narrow than expected. The rights are taking longer to issue. Maybe there's freedom to operate issues, so third parties are holding patents to improvements or to the main technology, or maybe the other side is that maybe third parties are already infringing the licensed rights, and the licensor isn't dealing with that as effectively as the licensee would like to have happen. Now, some of these issues can be resolved in due diligence. In other words, sometimes I think you see these issues because the licensee just didn't bother to read the patent or the, you know, carefully enough. It didn't bother to look at the prior art in relation to patents or trademarks carefully enough. It didn't bother to really try to dive into, say, the confidential information being licensed or the data being licensed to see what it really was. And in those cases, sometimes the licensor will come back and say, well, it's caveat emptor. The things you're complaining about, you could have, with adequate or proper due diligence, been aware of this on day one. We're not going to give you a reduction in royalty rate because you forgot to look at the file wrapper, or because you forgot to, you know, sort of take a look at prior art, even prior art that had been cited by a patent examiner. One issue that I see commonly in licensing arising from academic R&D, so that could be sort of IP arising from a university or a hospital or a research organization like NRC, is that quite often the system or the technology that's required to generate data for an academic publication is not equal to, in fact, it's much less than the system or technology required for commercial deployment. So there's I've seen this happen so many times where what happens is a patent is filed, and the principal investigator or somebody on that team says, oh, this is amazing technology, and look, we published this paper in a leading publication, Science or Nature or another key journal in the area. And the licensee gets all excited about that and thinks, this is great, this is amazing technology. It really would appear to address a really significant and validated market need. This is going to be great. But then what happens is it turns out that the academic research was done on a small scale, and there are big problems in scaling the technology up. You see this in certain types of computer science. Optimization would be an example of that. Some types of artificial intelligence and machine learning. You also see this in chemical engineering, where things that work at the 100 milliliter scale on a lab bench don't work at the tens of thousands or millions of liter capacity in a big chemical plant. Quite often, academic research overlooks and isn't clear and transparent about how reliable or unreliable the systems or the technology is. And so the academic research doesn't point out that, the experimenter ran this experiment, 10 times to get one time that worked properly. That somehow the experimental system was so fragile or temperamental, or so affected by, what are thought to be extraneous variables, that in fact, it's radically harder than is thought to get good outcomes and good results. So if you think about the incentives for academic researchers and for graduate students, at the end of the day, they want to get positive results. And although, especially in the area of pharma and biotech, those areas are getting better at having registries, say, of clinical trials, so that you can become aware when there's a negative clinical trial, for example. In other areas of research, that's far less common. And it could be that, some academic researcher has done a certain set of experiments many times and had bad results, and finally they maybe get lucky, or maybe, experience a statistical anomaly and get good results when really the results are not really that reproducible. And if you follow sort of writings in this area, in some areas of practice research, academic research, there's a tremendous problem now with sort of reproducibility, that results that occur cannot be reproduced by other sort of labs and other scientists, which is a big problem. Another problem that happens in academic research is that the user interfaces are very complicated and unfriendly. And, you can visualize this in terms of, the experimental setup, has 50 dials on the front of the control console, whereas in an industrial setting, the most that they might put up with is 2 or 3 dials, right? Sometimes the systems aren't durable. Sometimes there are really high efficiency, or efficiency is a problem. It could be energy efficiency, water efficiency, or the input costs. The costs of raw material are extravagant or extraordinary. Sometimes what happens is there's a narrow functional window. For example, in the little fact pattern that I gave you before Jennifer and I, or at the start of the demonstration of negotiating and drafting indemnities, I gave you some technology with a very narrow functional window, which creates all sorts of problems and difficulties. Okay. So those are, reasons why a licensee might complain about the technology or the rights they've obtained from a licensor. The licensee, on the other hand, may have its own challenges. It may be, ineffective or lacking resources or priorities to bring products to market. It may have a weak business plan or strategy. It may be weak operationally. It may be underfunded. So, I see this underfunding problem happen a lot where a licensee, might be a startup company, licenses the rights from a hospital or university. They think they're going to be able to go out and raise $500,000 or $1 million or a couple million in, seed stage financing to move the project along, and they just can't raise the financing, which really limits their ability to carry out R&D and marketing and other, business development type activities. I think the other thing is that, quite often all these things in terms of building new products or building a startup company, they're just really challenging things to do. And it's interesting, 25 years ago, we thought that the optimal founder of a startup business would be a tenured university professor. We now don't think that so much anymore. And we now think, out of that sector, the best person is probably a postdoc, someone who's got really good training, but the startup business will be their full-time business. So it's interesting how things change in that regard. So generally, renegotiation is motivated by a failure of one or both parties to meet expectations. And those expectations, if you try to sort of get some clarity or elaboration from that, from a client, can often be expressed as examples of something that could happen or shouldn't happen, goals, models, projections, or budgets. But when the parties, so it wouldn't, one sort of dispute that I sometimes advise on is, where a licensor says they're taking longer to bring this product to market than I thought they would. But then you can say, well, were the expectations around that, common? Were they mutual? Were they objective and quantitative? Were they realistic? So sometimes one of the problems that leads to renegotiation is that the parties either were either very vague or even not even or any expectations about performance, or either performance by licensee of the tasks they'd carry out, or performance by the licensor about the quality of the rights or the quality of the technology that was being licensed, are implied or vague. So an example of this that I sometimes see is sometimes hospitals and universities will simply say something along the lines of, the licensee will carry out, good or reasonable or best efforts to commercialize the technology. And if they materially fail to do so, the licensor can terminate the license. And the challenge with that sort of clause is that it's so vague that the licensees often in a situation like that will worry that they can be terminated on what effectively is a subjective evaluation by the licensor that the licensee isn't doing the performing adequately. So in situations like that, with some types of technology, you can set out standards. You can say, if it's chemical engineering, for example, you can say within 6 months, you'll prove that you can do this particular reaction at this scale, and the output of that chemical reaction will have certain, will conform to certain parameters in terms of performance and quality. It'll have this level of purity. It won't have, this problem. It'll, maybe have this energy consumption or this water, consumption, or whatever the relevant parameters are. And the benefit of trying to elaborate upon expectations, however they are, is that the expectations can be used as both a basis for negotiation, but also a basis for renegotiation. They may be, and we'll talk a bit more about this, I think, when Jennifer talks, they may be also as a basis for decisions not to renew license agreements. And so these are all some good things that, you know, objective and quantifiable and stated in the contract expectations can be used for. A challenge is sometimes it can be difficult to gather meaningful data to form the basis of the expectation. Sometimes parties don't either have the expertise or want to invest the money to actually formulate these expectations. Because those good faith contract performance obligations affect both contract performance, rights to terminate, obligations around renewal. And so I think that flavors all of this as well. And a question here is, could expectations be set out in a quality control clause or in a section on its own? And I would say both. It certainly would be, some of these expectations would be very relevant to quality control. They might also be very relevant just standing on their own. And this hopefully will become a bit more clear as we dive more into this. So one practice point or suggestion here is that in your IP license agreements or similar transactions, that you create written data or documents that capture expectations and elaborate them, that articulate them, that make them clear and part of the contract. So things that could be expectations might be projected sales. It could be projected profitability. It could be projected investment. So I think University of Toronto has a pretty common clause where they say they often grant an option to IP rights. You know, the option might run 6 months. And, you know, a pretty common clause that University of Toronto has is they would say, and once the optionee or the prospective licensee raises $500,000 in investment, then we'll negotiate a license agreement in good faith. You know, now I don't mind the part of that where there's a clear performance requirement, which is go raise some investment and here's how much you have to raise. I think that's a good approach by U of T. Where I fault or criticize or critique U of T on that approach is the clause that says that they'll negotiate an IP license in good faith is effectively legally meaningless. So they've told the licensee to go raise, or they're not really a licensee, they're just an option holder, but it's an option to do nothing. And on the various occasions when I've advised potential licensees under that scenario, I tell them, it's worthwhile to spend the time to actually negotiate the license terms immediately. You know, it still may be a condition to entering into that negotiated license agreement that you have to raise the $500,000 or $1 or $1.5 million before it kicks in. But it's important that you be crystal clear what the terms and conditions of that license agreement are going to be, what the scope of the grant's going to be, what the representations and warranties and indemnities are going to be, and limitation of liability and performance covenants and all of that sort of thing. So some other things that could be used to capture expectations might be some various timelines. So time to bring products to market, to meet technical milestones, to meet sales targets, so those are all things related to timing. You could also have expectations related to marketing spend or other budgets, you know, the cost to meet technical milestones, the cost of substitutes and complements, the cost of required third-party rights. And then you could also have expectations about the scope of the rights. You could say, you know, we've promised to pay a 5% royalty, but we expect that, you know, the main, you know, let's say it's a patent under examination, or a patent application under examination, but provided that the examiner approves in the relevant market, the US and Canada, a patent that's comparable in scope to claim 1 of the currently pending application. That could be the sort of thing that you might say. Or provided that licensee doesn't become aware of significantly invalidating prior art. That might be another way to characterize an expectation. So I think I can assure you that this is an approach that will align the parties' interests better, that will reduce disputes, that will make it more clear sort of rights of termination, rights of renewal, that will help the parties align on what needs to be done to have a good working relationship. But one caveat here is that parties may be reluctant to share the information required to draft performance covenants, but such sharing will, but on the other hand, the sharing facilitates negotiations. So as the advisor to these parties, I'd advise you to urge them to share information and write down and include in your contracts the basis of common expectations. So other clauses that can help align expectations are things like assumptions clauses. So you can say, we assume that, it will take no more than $500,000 of properly invested money or cost to develop a, fully functional version of this product. We've talked a little bit about full disclosure clauses and royalty stacking clauses. You can also have things like self-help clauses, partial termination, and renegotiation, and I'll talk a little bit about those. So let's talk about some of these different clauses. Examples of performance covenants might be something like the licensee will spend a certain stated amount of money on anything that's relevant, right? It could be developing a commercially viable product. It could be obtaining regulatory approvals. It could be spending money on marketing and advertising. Quite often that's more relevant to trademark licensing or on business development. This is just sort of a starting point for how you draft these clauses. Typically, you would want that money spent within a certain period of time. You might want to have a supporting clause that says, and they'll have that money in the bank, or they already have that money in the bank, or they're going to raise that money. And then each of these things, you could more properly define what it means to have a commercially viable product, or what regulatory approvals are required, or what business development means. Another really important type of performance covenant is various what I would call technical covenants. So something along the lines of, licensee will achieve by a certain date technical performance milestone, or the product or the process will conform to a certain technical standard. Or they'll have, something into beta testing, or they'll have achieved a certain production capacity, or they'll have achieved sales in specified markets, which could be a first sale, an aggregate sale, or an annual sale. And then for clauses like that, you might want to also say something like a bona fide sale to an arm's length party on reasonable commercial or terms and conditions. In other words, you want to give some thought to licensee trying to avoid any of these clauses by some sort of a fictitious transaction or a bad faith or a colorable transaction. Some other example of performance covenants could be things like the licensee will hire people into the following positions, obtain a certain investment, implement a budget where the budget is attached as a schedule to the contract, or implement a project plan, also attached as a schedule to the contract or the license agreement, or both. Implement the budget in accordance with a particular project plan using particular people. So those are examples of performance covenants on a licensee. Examples of performance covenants on a licensor would be to do something like prosecute the rights as promptly as possible, and generally prepare responses within 1 month of first receiving an office action. The reason why a licensee might want to put that performance covenant on a licensor when there are pending rights is sometimes there are incentives created in license agreements for licensors not to want to prosecute the rights as promptly as possible, but the exact opposite, to prosecute them as slowly as possible. Maybe they have some idea that the rights aren't terribly valid, and if that was validated, or if that potential invalidity was validated by the scope of issued rights or approved rights by a patent examiner or a trademark examiner, then the licensee would walk away, or maybe they'd have certain rights under the contract, rights of termination or reduced royalty or what have you. So that might be an example of a performance covenant that could be put on a licensor. Okay. Full disclosure clauses might be clauses like, Party A has disclosed to Party B any information and documents in its possession or control that might reasonably affect the licensee's ability to fully exploit the rights, performance obligations, and evaluate the transaction. When I'm acting for the beneficiary of this sort of clause, I sort of like it, but I understand why the party being asked to give it has some hesitation about it. The benefit of these sort of clauses is that it avoids gotchas. It avoids one party sitting on information that would affect either whether the other party wanted to do the deal or very materially might affect the terms of the deal. They're sitting on it. They've got it. They just don't want to tell the other party. Full disclosure clauses also help foster trust. They're particularly relevant when, say, there might be a large upfront initial fee or contract execution fee, or when one of the parties has large opportunity costs. The downside of a full disclosure clause is, one, they don't replace the need for due diligence. And it requires the party giving that rep and warranty to know a lot about the counterparty, to know that, to kind of understand what the counterparty would find as relevant to be disclosed. So I wouldn't say, when you actually negotiate these clauses, they're not easy to manage, and they're not easy to draft and negotiate. And sometimes there's an ongoing duty or obligation of full disclosure. And again, that's not necessarily a trivial thing to manage to manage operationally, but I think sometimes they're worthwhile clauses. I've mentioned royalty stacking clauses a few times. These are the clauses that permit a licensee to deduct from the royalties that would ordinarily be paid under the licensor, and they can deduct from those royalties amounts paid to third parties for enabling rights. Often they're limited to amounts actually paid. You don't want to, if you're going to include a royalty stacking clause, usually you don't want to say that the deduction can be made if the amounts to be paid to the third party are merely hypothetical. Often there's a rough industry standard that royalty stack clauses are limited to reducing half the negotiated royalties. And you commonly see this in pharma and biotech. We're starting to see it a little bit more in other areas of technology. The benefit of a royalty stacking clause is it goes a long way to reasonably allocating the risk that if third-party rights are required, if there's a freedom to operate problem, that it can be allocated and addressed in the economics of the deal. So that's a good thing about them. So another good sort of alignment clause and self-help clause, I would say, is what I would call partial termination rights. So this is where a licensee fails to meet some form of expectations. The licensor can do something other than a complete termination of the license, right? Because sometimes the licensee is performing well in some regards, but not in other regards. So they might be doing a good job in one country, but not in other countries. They might be doing a good job in certain fields of use, but not other fields of use. So by a partial termination, this is the sort of clause that says, if licensee fails to meet the expectations, licensor may, at its option, reduce the field of use or reduce the territory or change exclusive rights to non-exclusive rights or some combination of these things. And I find that these partial termination rights are a really good idea. They often help parties find a better long-term solution to their difficulties. Often, though, they need to be based on some reasonable and clear definition of not meeting expectations. Otherwise, it just puts too much discretion into the hands of the licensor. Some self-help measures might be where a party fails to meet a contractual obligation, the other party may fulfill that obligation at the cost and expense of the breaching party. So a great example of this would be if the licensor is supposed to pay patent or trademark maintenance fees and they don't, the licensee can step in and under the contract is authorized to give the licensor's patent or trademark agent instruction to pay those government fees, those maintenance fees. Another example of a self-help measure might be where a licensor is in breach of its obligations, the licensee may withhold royalty payments or may set off its costs arising from the breach against royalty payments. Or another example of self-help measures might be, that if the licensees in breach, the licensor might be able to disable the technology or refuse to provide support or refuse to provide technology transfer or improvements, et cetera, et cetera. Okay. So sometimes you will have a formal renegotiation clause, which, typically reads along the lines of the parties will negotiate in good faith for a period of at least a certain number of days, it might be 30, 60, 90, prior to the expiry of any termination of rights to renew the agreement, and determine if any terms and conditions need to be amended to permit the parties to meet and achieve their reasonable expectations. My one caution or a caution about this type of clause is that if it's unclear what the standards would be for renegotiation, or the basis for renewal or something like that, it could be that this clause will be found to be legally unenforceable. In other words, it's void for vagueness. So I would caution that. I think it's good to have obligations to consult with each other. I'm not sure that often you can go much beyond that, but I still think it's worthwhile to perhaps include a clause that says, at the very least, the parties for, say, 30 days before termination or before the end of the term, they'll at least have some discussions. Okay. Now, shifting to renegotiation or talking about sort of the subject matter of renegotiation, it often centers around economic terms of the deal, but it can also discuss territory, field of use, sales of substitutes by the licensee or various aspects of non-competition clauses, perhaps licenses to improvements and performance covenants. Those are all things that could be covered by renegotiation. In terms of dispute resolution, I'm just going to talk about escalation clauses, tips and hints for effective dispute resolution, managing mediators and arbitration clauses. So escalation clauses are actually related to termination clauses and related to renegotiation. And these are the sort of clauses that require the parties to have some sort of structured discussions to attempt to negotiate resolutions to a dispute if one of the parties feels that there's a dispute in place. So this is encouraging the parties to have some form of constructive dialogue and interaction prior to launching a lawsuit or legal proceedings in court or arbitration proceedings. So escalation clauses often require, and I think good ones require, the parties to put in writing what the dispute is, put in writing at least one suggested resolution, and provide key documents or information to support their position. I think if you have those things as part of the sort of escalation clause, that can go a long way to identifying disputes that can be resolved easily and early. I think another important thing in an escalation clause is to make sure that the dispute will be escalated to more senior managers, simply because managers at different levels of an organization, you know, as Jennifer was talking about this morning, sometimes they have different risk tolerance, sometimes they have a different experience base, sometimes they have a different sort of set of perspectives and knowledge. Sometimes what they're evaluated on in terms of their performance, like their yearly or other periodic performance review, may be affected by how they approach the issues in dispute. So sometimes more junior people are reluctant to resolve the dispute because it will affect their performance evaluation. And more senior people may not have those same concerns. So for all of these reasons, I think it's often valuable to have a clause along the lines of saying, you know, after 30 days of good faith discussion, and after you've, you know, exchanged the written statement of a dispute and suggested resolutions and a key document or information, if the dispute isn't resolved, then it will go to, and then often you would name, sometimes you go right to the CEO, sometimes you might have various stages of escalating to more senior managers. Sometimes you'll name a specific person, sometimes you'll just name a title or role. So in terms of some tips and hints for effective dispute resolution, it's a good idea to carry out due diligence prior to negotiating and executing the agreement. Usually the most effective time to resolve a dispute is before while you're negotiating a contract. And in other words, be proactive and avoid the dispute before it arises. And you avoid a lot of dispute by negotiating and drafting good contracts that are comprehensive and even-handed. Another important thing in terms of avoiding or limiting the effect of disputes is to create a paper trail highlighting underperformance and breach. And we'll talk a little bit more about this sort of starting at 3 o'clock when Jennifer comes by to talk about termination and renewal of the license. But I will say that it's a very common problem in disputes that one party can claim credibly that it wasn't aware of the dispute, or it thought the other party didn't think it was material, or that the other party thought it was resolved, right? So you need to point out to the other party where they're underperforming or in breach. And for reasons that we'll get into, you also, if, you know, lots of contracts and the boilerplate for contracts contain a waiver clause, you know, and a waiver clause typically says, just because we haven't terminated for a breach doesn't mean we can't terminate for that breach at a later date or terminate for a similar breach at a later time. But it's actually kind of hard to make those clauses enforceable in court. So courts have some tendency to override that boilerplate and simply say you have irrevocably waived your rights to terminate for breach. So it actually is harder than it looks to terminate a contract for breach. And it's even just hard to build your position that the other party's in breach. So you need to create that proper paper trail. It's usually a good idea to talk to a litigation lawyer when you suspect you might have a dispute. And then quite often what you're doing is you're building your case and position. You're not, sometimes you have a dispute where there's breach of the contract and you're contemplating suing right away. But as often as that, or more often, you're actually building your case or your position over a series of months before you get to the position where you can send that final, a demand letter, a cease and desist letter, or something like that. You should also consider who can most effectively communicate with the other side, who's got good constructive channels of communication, and the opposite, who's got perhaps dysfunctional channels of communication and quite often contracts can contain some obligation to go into mediation. I will just give you sort of a flag that there are generally two types of mediators. Some are simply facilitative, where they will simply encourage constructive professional dialogue between the parties, or they'll shuttle messages and positions back and forth. There are evaluative mediators who will look at a party and say, you know, here's where your argument is weak. Here's where your argument is strong. This is what I think you could be, you know, here's what you could gain out of this dispute. Here's what you could lose out of this dispute. The former type of mediator is more common in part because you either need a lot more experience or a lot more preparation time to be evaluative. So you should consider sort of in managing mediation and mediators, what issues you want the mediator to give their opinion about, what information the mediator requires, how much time the mediator has to prepare, and what expertise the mediator requires. In something like intellectual property licensing, I think it's a good idea to say, if you're going to have a mediation clause, say the mediator shall have prior experience in intellectual property licensing. Because if you just get a generic retired judge to be your mediator or a generic business law litigator, they may not know enough about intellectual property to be able to move the mediation along. And I've seen that happen quite a lot. You should also give some thought to, like, a lot of mediators will spend a half day of preparation or no more than a full day of preparation, although I'll be honest with you, a lot of mediators are closer to a half day of preparation. It's very, you need to be realistic about what issues they can turn their mind to in half an hour or half a day, right? That's not very many issues. It's not, they're not going to dive into deep technical problems or deep issues around, you know, underperformance, or if there's any thorny legal questions. So you want to give some thought to, you know, maybe a clause that says, and the parties shall give the mediator adequate time to prepare to address the issues in dispute in the mediation, you know, or the mediator shall be instructed to give a non-binding evaluation of key issues in the dispute. Arbitration clauses are common. There's two key advantages to having an arbitration clause. One is that you can maintain the confidentiality. So it's interesting, I've got one licensing dispute that's playing out in the Ontario courts right now. And one aspect of that is that you know, we need to, you know, on the one hand, one of the parties wants to protect the confidentiality of who its customer list is, and the other party wants to protect the confidentiality of some of its licensed confidential information. So that's something we're going to have to address. So preservation of confidentiality is an important advantage of arbitration, in part because we generally have an open court system. Generally, in our open courts, there's no protection of what you might call commercial confidentiality. There's a bit, but it's not guaranteed and it's limited. So that's one benefit of arbitration. The other benefit of arbitration is that you can specify some background knowledge or expertise of your arbitrator. You can ask for an arbitrator with expertise in intellectual property or intellectual property licensing. And I think that's really important, because I think that parties to a dispute around, say, an intellectual property license agreement run a big risk if the arbitrator, for example, or the judge, knows nothing about intellectual property, because then you really run the risk that they're going to make their decision on issues that are peripheral or tangential to the real issues, okay? And you should assume, if you're going to court, or if you just have a randomly appointed arbitrator, that they will have no expertise in intellectual property or licensing. So arbitration clauses, you might often want to set out the location of the arbitration, the language of the arbitration, as I've said, whether the arbitrator has special expertise. And you want to make sure the arbitrator has adequate powers to do things like order documents to be produced, to make interlocutory rulings or rulings before the final determination or trial on the merits, to perhaps order some aspects of discovery, maybe to be able to order injunctions and to award costs or partial costs or interim costs. Okay. Some people think arbitrators should be asked to promise to provide best efforts to provide a judgment or reasons within a period of time. I'm not sure that's reasonable, because that makes a lot of assumptions about the availability of the arbitrator and how fast they can move. So I think, you can, the other nice thing about arbitration is you can actually do some reference checking on your arbitrator and see things like this, do they get their reasons and judgments out reasonably promptly? In international arbitration, it's common to have 3 arbitrators, and there's some benefits to that in terms of getting even-handed, nicely balanced rulings and judgments, but it is very expensive. Sometimes, if you want to save the most money, you could just tell the arbitrator in your contract, like in the main license agreement, to give no reasons, to simply make orders for remedies. But in my experience, parties find that difficult. They want to see at least some reasons. Having said that, you can also specify how extensive those reasons are, whether they're just the reasons required to support the judgment and award, or is the arbitrator required to canvass all the evidence and argument. Okay. There are some advantages to, or alternatives rather, to arbitration. Early neutral evaluation is, where a party like a mediator or an arbitrator gives an independent but non-binding evaluation of key issues. That can be really helpful. There is a scenario in which parties have either drunk their own Kool-Aid and they might not have a particularly strong position, but they are really reluctant to open their eyes to the weakness of their position. So that sometimes happens. And sometimes, I'll be honest with you, that's the lawyer's fault. The lawyer, and sometimes, not often, not always, but sometimes lawyers, lawyers have there are principal agent problems between lawyers and clients. Sometimes lawyers want to make legal fees off a file, and they are reluctant to tell their client they have a weak case or even an outright loser of a case, because they want to collect legal fees on it. And so sometimes either evaluative mediation or something like early neutral evaluation can help move things along. A hybrid approach to mediation and arbitration is called Medi-Arb, and that's a period of mediation followed by and if that doesn't produce a settlement, then the mediator becomes the arbitrator. I've used this a number of times, and it's been quite successful. The disadvantage of this is that settlement positions are disclosed right out from the outset to the person who will end up being the arbitrator. The benefit is that it really encourages parties to take a more reasonable position, both in the mediation and generally. So I think Medi-Arb, the risk or the threat that your mediator will turn around as soon as the mediation is done or terminated or unsuccessful and become your arbitrator, I think encourages parties to compromise and take a big and resolve disputes. That is what I had here. Are there any questions?